Brendan Dassey trial transcripts, day 1, continuation of the defense's opening statements, beginning on page 90 of the transcripts. But again, this is Brendan Dassey's trial, not Stephen's trial. It's about a 16-year-old boy at the time. It's about a 16-year-old high school student with below average cognitive abilities, a 4th grade reading level, a low IQ. It's about a shy introvert, socially inept, suggestible child. That's what this trial is about. You'll learn that this shy, socially inept, suggestible individual will meet 2 highly trained, intelligent adult police officers, DCI agent Tom Fassbender and investigator Mark Wiegert. They're trained as adult law enforcement officers, trained to obtain confessions, and trained on Brendan Dassey. Alone with these 2 officers, Brendan makes several statements, as Mr. Kratz has already alluded to in his PowerPoint presentation, in his opening statement. It starts off in a progression where Brendan says Stephen Avery killed Teresa Halbach, and it progresses to the point where he indicates he participated. And the state will argue to you later and offer evidence throughout the trial, through the officers, that they believe that this progression of audio taped statements from at the school, the videotape taped statements at the police station, and then the final May 13 videotape statement as a progression to the final truth. What we want you to consider, 3 things. While you're watching these videotapes, and we agree very powerful videotapes, very important videotapes, but like in a story, 2 different stories, there's a different perspective, a different theme. We want you to look at 3 things. Corroboration, similar to what the state offered. They want you to look at what it corroborated. We want you to also focus on what is not corroborated. There are dozens of details that go uncorroborated in these statements. Corroboration simply means that there's something independent that can prove the statements are true. Some other independent source that suggests that what you heard is accurate. But there are dozens of instances where their details are uncorroborated. The second to consider is the inconsistencies. There are a number of inconsistencies throughout this progression of statements. When you watch these statements, take note of the different changes from one statement to the next. Simple. Details that seem to be mundane, unnecessary, change from statement to statement. And though the state will try to suggest that it's an escalating progression from the first time they met with Brendan Dassey to the last time he talked to them, it's really a roller coaster ride of the truth, up and down. One statement says one thing, the next says the other, and it just goes that way throughout this progression. Some of the changes are not logical, oftentimes detached from the purpose of the investigation. Sometimes it's the product of the interviewer. Watch for that as well when you're watching these videos. Oftentimes you'll hear the investigators asking Brendan to simply change what he said. They ask him to change what he said to meet their theme, to meet the story that they want to present. And last, we want to ask you to watch the video for, lack of a better term, the appeals to emotions the officers make throughout the different statements to Brendan. This 16-year-old low intellectual ability, low cognitive ability, shy introvert, they're asking him and they're appealing to emotion. Watch how he answers the questions. Watch how the questions are asked. At times it differs. Times they cozy up to Brendan to get the answer they want. At times they pull back from Brendan when he's not giving them the answer they want and they expect. It's like the new puppy dog. When he does what he's supposed to do, he gets a pat on the head and a treat. Good job, Brendan. Good job. Good boy. But when it's not what they want, we're leaving Brendan until you tell us what we want to hear. I believe these statements are very powerful, and I agree with the state that you need to take considerable effort to watch them. Take notes. I encourage you, take notes. We've seen these videos a number of times. You may only get to see this one time, and I would encourage you to take notes throughout, but not just to what is said. Take notes on how it's said, how the questions are asked, how it goes from, I didn't say that, or I don't know, to the answer the police got that they wanted. The facial expressions, the distance between the interviewer or the interrogator and Brendan, the interaction physically between the 2. I believe that when you watch the videos carefully, they'll be exposed for what they are, and I think they're just garbage. And just like that, you can discard it. You'll be instructed by the judge later that you decide what and how much you want to believe. It's entirely up to you. Now, I think these 3 focal points of the statements are important to note because the state won't explain to you why there are uncorroborated details, why there are so many inconsistencies, but we will. We'll provide testimony that shows from his school, describes him as having low cognitive functioning, memory problems, 4th grade reading level, fails to make eye contact with peers and adults, and avoids participation. A forensic psychologist will also testify, and testify as to tests that he performed on Brendan that indicate that he's a socially inept child, substantially impaired cognitively. He has passive tendencies and vulnerable to suggestion. Coupled with this testimony and the videos, I believe will show you how easily Brendan is manipulated and was manipulated. Manipulated by the more intelligent, readily trained, authoritative figures, the two police officers who presses me when he says good things they want to hear, and pull away and sternly isolate him when he says things that they don't want to hear. Despite these statements, the lack of scientific evidence to connect Brendan to Teresa Halbach's murder, the volume of uncorroborated details, the roller coaster of changes in his statements from one to another, the psychological results in his psychological makeup, his suggestible nature, will all be enough, we believe, for you to find reasonable doubt. And that's what this is about. As the judge instructed you, you have to decide this case based on what is reasonable doubt. And the judge will give you another instruction at the end as well, not just before, but also before you retire to make your final decision. If at the end you walk into the jury room and you considered all of the evidence from all the parties, give them whatever weight the credibility of each witness, whatever weight you wish to give, and you're able to say, well, the state's case does make sense as well as the defense, their case does make sense, you would then have a reasonable doubt, and that's all we're asking you to consider, and you must stop. It's not a contest. This isn't a competition. It's not a basketball game where somebody has to show up and win at the end. You don't have to reconcile the state's case with the defense case. In fact, you shouldn't. That's not your role. Your role isn't to decide in that situation who wins. You don't have to reconcile doubt. As the state attempts to prove beyond a reasonable doubt the allegations against Brendan, consider the number of times that we feel Brendan was manipulated during his interrogation, and we'll discuss that with the witnesses, and we'll make further our observations at the end. Consider all of the inconsistencies of the various statements as they go from one to the other. Consider the lies the police told Brendan during his statements. We believe after careful consideration of all of this, in the end, there would be only one conclusion you could write for this chapter in this story, and that would be not guilty. Thank you very much. The court. Mr. Kratz, Attorney Kratz, if we could approach just briefly, Judge. Discussion off the record. The court. All right. We're going to adjourn and take a lunch break. We'll be back here at 1 o'clock. I'll remind the jury there's no discussion of this case at this time amongst you. All right. 1 o'clock. Jurors out at 11:40 a.m. The court. All right. 1 o'clock. Attorney Freeman. Will this courtroom be locked during the lunch break? The court. Sure, I believe it is. Yeah, okay, it will be. Recess had at 11:40 a.m. Reconvened at 1 p.m. Jurors not present. The court. Counsel, I'm informed that one or both of you have something to put on the record at this point. Attorney Fallon. Yes, good afternoon, Your Honor. The state would like to take up one evidentiary matter as it may pertain to anticipated cross-examination on a rule of evidence before the jury arrives. I'm not sure if opposing counsel has anything they wish to discuss. The court. Hearing none. Attorney Fallon. Hearing none. We noticed during the opening statement of the defense that there was reference to the May 13 interview of the defendant, Mr. Dassey. We wanted to take time to point out that, first of all, the state was contemplating, if at all, use of that information as part of its rebuttal case, and in all likelihood would not be introducing that evidence in its case in chief. As such, the law is quite clear that those statements of the defendant can only be offered by the prosecution, because then they would be offered by a party opponent. And as further evidence in support of that proposition, I would cite State v. Pepin, 110 Wisconsin 2D 431, and State v. Johnson, 181 Wisconsin 2D 470, for the proposition that the defense would not be entitled to elicit that information on cross-examination of an officer unless and until the state introduces that evidence first. So we just wanted to make sure that we're clear on the rules of evidence, because if it were to be elicited by the defense, then it would not be a statement of a party opponent. It would be elicited by the same party. The court. Mr. Freeman or Mr. Edelstein, any response? Attorney Edelstein. Your Honor, at this time, having heard the argument of counsel, I would ask the court reserve any ruling on that matter and allow us an opportunity to review the authority cited by counsel. We did discuss it very briefly before court convened after noon here. We have not had the chance to review that matter, and of course the basis of some of the state's evidence, which they clearly indicated they intend to introduce, including in their case in chief, not the least of which is the May 13 telephone call, so intricately tied to that statement of May 13. I think this needs further examination before we can appropriately respond to the state's anticipatory objection. Attorney Fallon. Well, just two minor points. We never mentioned anything about any May 13 statement in the opening remarks. And number two, just so the record is clear, the objection right now, the appropriate objection to attempt at cross on that would be a hearsay objection. So if the court chooses to defer ruling until later, that's fine, but we do have an officer taking the stand later this afternoon, so the court. Yeah, I will defer ruling, but it's my understanding, Mr. Edelstein, that the proposed, or I shouldn't say the proposed, the statements from the May 13 interview would be admissions by a party opponents under 90801 4B1, and it seems to me you are precluded at this stage, at least, from asking about them. Again, we'll flush this out a little later on, but if that's what you're asking. Attorney Edelstein, Your Honor, I think it's going to depend upon precisely what the officer testifies to. If he goes anywhere near any statements that he participated in, be they characterized as statements or confessions that involved our client, I think irregardless of the date, there are certain areas that we have, particularly on cross, leeway to get into. I don't know if that's the purpose of any of his testimony here this afternoon, but if he does go there, I would ask that we be notified in advance, or at least certainly be given an opportunity prior to any cross to have this matter addressed by the court, including an opportunity to review the case as cited by the state. The court. All right, let's proceed. Mr. Kratz, we'll get the jury in here, and we'll get your witnesses. Your witness. Jurors in at 1:07 p.m. Attorney Kratz. State would call Karen Halbach. Karen Halbach, called as a witness herein, having been first duly sworn, was examined and testified as follows. The clerk. Please be seated. Please state your name and spell your last name for the record. The witness. Karen Halbach, Halbach. Direct examination by Attorney Kratz. Good afternoon, Ms. Halbach. Could you tell me, the jury, please, whether or not you knew a young lady by the name of Teresa Halbach? Yes, I did. You have to pull the microphone down nice and close for us, please. Who was Teresa? She was my daughter, the second oldest in my family of 5 children. She's a very caring and very loving young woman. She was very dedicated to her family and friends. She was a hard worker. She had a great sense of humor. She was also the life of the party. She had an ability to make people smile, and I think that's why she enjoyed photography, because kids really responded to her. Kratz. All right. You told me that there were other children in your family as well. Could you identify them? Tim is the oldest, and then there's Teresa, and then Mike, and then I have 2 younger girls, Katie and Kelly. Kratz. Could you tell the jury, please, where Teresa lived? She lived next door to us, about a quarter mile west of us. My husband and I own the farmhouse, and she lived there about a year before she died. Going to hand you what's been marked for identification as exhibit number 1. Could you tell the jury what that is, please? It's a picture of Teresa. We'll be showing the jury photographs as well. When you say that Teresa lived next door to you, can you describe that a little further, please? Well, she lived a quarter mile west from us in a farmhouse that we own. Her rent was going to go up. She wanted to live someplace cheaper, so I said, why don't you move closer to home, so we'd really give you a deal on rent. So she took us up on it, and, we enjoyed having her there. All right, I know you mentioned briefly about Teresa's background, but did she have post-high school education? She went 4 years to UWGB. She graduated in 2002, summa cum laude. And GB, that's Green Bay? Right. After that, I think you've already mentioned briefly of the kind of work that Teresa went into, but can you describe that a little more fully? What type of employment did she have? In her final semester at GB, she started an internship with Tom Pierce Photography in Green Bay, and then after she graduated, she continued working with him, and then she realized she wanted to own her own business, so she started Photography by Teresa, and she also worked part-time for Auto Trader magazine. All right, this photography studio, did she have any areas of expertise within that studio? Any kind of portraits that she enjoyed more than others taking pictures of? Well, she especially liked taking pictures of kids. She was good with kids, but she also did weddings, graduation photos. If you had an event that you wanted pictures taken, she would gladly do it for you. Mr. Wiegert's going to hand you what's now been marked as exhibit number 2. If I'm able to do this, tell us what this is, please. It's a picture of Teresa.